Good afternoon, everyone. Thank you for joining us for the last session of the Connecticut Affordable Housing Conference. My name is Carlene Shamos. I'm the Operations and Equity Director here at the Partnership for Strong Communities. I also have Samaila, a Research and Policy Fellow, joining me to assist a wonderful panelists. This year, the CAHC is here for housing. It is our opportunity to convene, collaborate, and drive meaningful change to improve and expand housing affordability, creation, choice, and stability across our state. You can join the conversation at hashtag CAHC 2024 across social. The session is titled Untangling Current Threats to Connecticut Homeownership. Before we turn it over to our presenters, we would like to thank our presenting sponsor, the Connecticut Housing Finance Authority, a visionary sponsor, Wells Fargo, our champion sponsors, Liberty Bank, the Connecticut Department of Housing, Klong, Flexnick, Trinity Financial, JD Amelia and Associate, and Robinson and Co. And thank you to our foundation sponsors. These sponsors support helps make the conference happen each year and keeps it free for everyone to attend. Last but not least, a big thank you to our featured investors, Connecticut Realtors and POA. A few housekeeping items before we get started. The session is being recorded and we will make all the recordings available as soon as possible. Please remain on mute unless the speaker asks you to unmute. If you have a technology issues, please feel free to contact myself, Carlene, or Samaila in the chat icon and the Zoom control panel. Your speakers will let you know how they would like content questions to be submitted. And after the session, you have a session feedback survey, and you can access it by clicking on the megaphone icon in the lobby. We truly appreciate your feedback. And with that, I'm going to turn it over to Teresa to get us started.
Good afternoon, everyone. First, just a heartfelt thanks to PSC and the Connecticut Affordable Housing Conference for having us. We're so grateful to be here. I am going to attempt to share my screen and get us started. So if you are here for the Untangling Current Threats to Connecticut Homeowners session, you are in the right place. My name is Tess Dudek, and I'm here with my colleague, Lorraine Martinez-Bellamy. We are staff attorneys at the Connecticut Fair Housing Center. And just a little bit about Connecticut Fair Housing to get us started. We are an organization that is centered around ensuring that all people in Connecticut have equal access to housing. And, you know, as you can see from our mission, we understand that this is deeply tied to issues of poverty, of race and housing discrimination. All of these issues go hand in hand, and we are committed to providing advocacy for our clients to ensure that everyone has a safe, affordable place to live. So we do that through several different branches of our work, including foreclosure prevention, education and outreach, policy advocacy, tenant empowerment and organizing, and fair housing enforcement. We have attorneys and non-attorneys on our staff, and we work across the state of Connecticut.
Because I left my notes on my desk downstairs, but I think this is fine. Hi, everyone. My name is Lorraine Martinez-Bellamy, like Tess mentioned. So we want to talk a little bit about why homeownership is so important for affordable housing landscape. Number one is there is a low housing, especially rental housing inventory, but honestly, like, yeah, as well as affordable housing you can purchase, there's also a low inventory for that as well, with high housing costs, especially after the last few years. during the pandemic, the market increasing 30%, and a lot of people that were getting ready to purchase properties being priced out by both the property costs increasing and interest rates later on during the pandemic increasing as well. It's also important as a way to transfer generational wealth, especially in communities of color. That is the main way that generational wealth is transferred. And we're going to talk a little bit about tangled title and how that plays into generational wealth as well. Neighborhood stability. Our focus is on keeping people in the neighborhoods that they chose in order to prevent instability. During the last foreclosure crisis, we saw a lot of neighborhoods that were targeted by reverse redlining, by crappy loans. We'll talk a little bit more about the legacy of that time period as well. And many neighborhoods, especially in the inner cities, like New Haven and Bridgeport, the houses were lost to foreclosure, creating a lot of instability, a lot of vacant property in the neighborhoods. And also homeownership gets more affordable over time. And Tess, that was your idea. So I want to give you an opportunity to expand on that.
Yeah, so as Lorraine mentioned, homeownership is not only just a way to build wealth, it also is a means of actually securing a place to live that is, as opposed to rents, which tend to increase over time compared to one's income. Homeownership, and because people are often in homes longer, that mortgage gets more affordable the longer you live in a property, and you aren't subject to the whims of the market, because that mortgage rate is, if it's a fixed mortgage rate, it stays the same. Your mortgage payments are going to stay relatively predictable over time. So it's a tool of housing cost predictability for people living in owner-occupied homes. And this one, I'm going to let Lorraine introduce us to the idea of tangled title. And Lorraine, I also have some poll questions to kind of help us take the temperature.
Sort of that.
Yeah.
I will not pretend to know how to work them.
So I'm going to open up the polls. We have some questions just to introduce you to some of the concepts that we have today. I know that, okay, so it looks like based on our responses here, we have some experts in housing among us, because our poll question answers are pretty good. So I know that question number one was, what is tangled title? So I will let Lorraine introduce us to that.
Absolutely. So back up a little bit, Tess.
Certainly.
Just one slide.
Sorry.
So these are the three topics that we're going to talk about today and dive deeper in. But like Tess said, since most of you seem to be up to date on them, we'll fast forward. So tangled title is a term of art really that we've used over the last few years to describe when a person passes and the title to the property is unclear. Either they have multiple heirs to the property. Most of these folks die intestate, or the will was never probated properly, so it's unclear who owns it. And for our purposes, the reason we care about it is a lot of these houses, a good portion of them tend to end up in foreclosure as a result of the fact that the untitled is unclear and nobody really knows how to take title to it or how to save the property. So homeowners will come to us when a family member has suddenly passed, and maybe they lived in the property with the person at the time, but they aren't really clear who the title would have passed through. And many of these properties, will have to go through some sort of probate unless the deed under which they owned it had was owned as joint tenants with rights of survivorship. And And many times it's shared, it's a shared home with only a single borrower. We see this a lot with multi-generational families living within one property. And often, especially like in the north end of Hartford and other parts of the inner city, it could be a multi-family property, but really one owner, and nobody else knows, who's next in line to inherit it. Sometimes the person that is next in line doesn't have the means to, or sometimes there's 5 people that co-own it by law and can't get on the same page about what to do with it moving forward. At times, there's the incarceration of a family member involved that's supposed to be the intended heir. And we tend to see this as well, most frequently in the Black community, secondarily in the Latino community. But the Black community owns a lot of property, and many times does not have a will or succession planning for that property.
So one of the things that we are seeing among the tangled title issues as they come to us, which is primarily through the work that we do in the foreclosure realm, is that often, even if there is an heir identified, that person has trouble getting the mortgage servicer to confirm them as what's called a successor in interest, which basically identifies them as a person who has some sort of interest in the property in terms of title, and is either living in the property or has not only an ownership interest, but potentially financial responsibility for it. Often, in order to go through the process of, for example, assuming the loan and taking it on in one's own name, you have to go through the process of being formally confirmed by the mortgage servicer as a successor in interest. And that process can be convoluted. It can be extremely onerous on the heirs, who are, in addition to grieving and trying to sort out their loved ones' affairs, now have the sort of stress of a timeline of the foreclosure, which in Connecticut is a judicial process and a civil lawsuit filed against, usually it's filed against the estate or the heirs in a tangled title situation. And frequently it can cause issues such as if it's an estate that's named in the case, but it's not actually the person who's living in the home that's named, they can't participate. So there's often some legal challenges to responding to the civil lawsuit, as well as dealing with the mortgage servicer to try and resolve whatever outstanding debt and arrears and complications have been left behind when their loved one passed away. So
I can take this.
yes, okay, thank you.
I'll put us back on track. I messed Tessa's order up a little bit by skipping one. So last year, in receiving lots of intakes with tangled title issues, we decided to do some research of our own. And we received a grant from Melville to look into, see how big of a problem this was within Connecticut. And we pulled, it was kind of qualitative in research, because we pulled both judicial data and then anecdotal information from our own intakes, and we're able to quantify it to a certain extent, but definitely not a perfect formula. It did give us an idea, though, of what we thought was occurring, which was that there was a good amount of equity being lost in tangled title issues. So we reviewed over 1,000 foreclosure cases, and I believe the time period that we chose was 2021 through 2023, so about 2 or 2.5 years of foreclosure cases. And we were looking for using terms such as estate or heir, and mining the judicial data that's publicly available, and then cross-checking names and addresses with obituaries and public records in order to try to identify the borrower's race. And then we also reviewed appraisal statements and the affidavits of debt that were filed on the public docket to confirm the home value that was at risk in each of these cases. And we were looking for non-borrowing heirs that had filed appearances, that were trying to move or save the property in some way. We also search for issues like quiet title claims or disputed claims in the property pleadings, multiple heirs with competing interests or represented by different attorneys, appearances with the same property address showing that the person that was seeking to be confirmed as a successor or as an heir lived in the property at the time, attempts at mediation, and mediation reports in our on our foreclosure dockets are public record. So you can kind of see and get an idea of what's been happening in mediation. What are the things that are holding people back within the foreclosure mediation process? What is keeping them from taking title or from being able to assume the mortgage or refinance the mortgage to keep the property? And any special filings, letters that they filed on docket, motions to intervene that were filed by parties that were interested in the property. One issue that we have had is that in Connecticut, the probate court documents, for I'm sure very good reason, are not public record. You can see if there's a probate case open, but you can't really tell what's going on beneath behind the scenes unless you represent one of the parties in the case. So there's only, we weren't able to get all of the tea on what was happening in each of these situations, but we were able to kind of patch together what was happening in many ways. We also looked at our own intakes for that same time period. You can go to the next slide, Tess. So we reviewed our database entries, and when we have a intake line where we receive calls from homeowners all across the state. We're one of the only organizations that provides pro bono legal advice for foreclosure in particular. So we do end up getting like a great sampling of what's happening on the ground very quickly, because I always say all roads lead to us if you're in foreclosure. So we looked at our database entries. We took a look at what were the issues that the people that we spoke to were having, and there was dozens of intakes related to issues with title. And we always ask people to self-identify their race and ethnicity for our grant purposes. So we had that data ourselves. We also, again, reviewed the dockets for home values, looked at as estimates on Zillow to kind of sort out what was the equity and the potential generational wealth that was at risk. Go for it.
So, in our intakes, one of the things that we identified was more than 4% of our intakes have tangled title issues, which doesn't sound like a lot. However, when you look at the ways that these disparately impact specific communities, particularly women and Black or African American people living in Connecticut, there is a pattern that we think warrants paying attention to. And the other element here is that there's a tremendous amount of wealth at stake. So many of these mortgages have been paid for years, and heirs are often left with a loan that really fell into default because someone was sick or maybe not paying the bills towards the end of their life. And while making payments is not an issue for someone, certainly suddenly having to come up with a large sum related to arrears and interest and costs that build up when a foreclosure case is filed does complicate trying to reinstate a loan or refinance, particularly because many of the loss mitigation tools that are used by mortgage servicers, such as loan modifications, aren't available to the heirs of a property when they are taking title to it after the borrower has passed away. So we did find, there is a average of equity at stake of over $117,000 or right around there for our intakes. So it's something to really pay attention to, because that risks being lost if a home is foreclosed on. So, and that was consistent with what we found in the judicial data as well. Any trends with regard to age? Oh, and I should have mentioned this. Please feel free to drop your questions in the chat. We are fairly casual about answering them, and I can't promise that we have answers, because with regard to age, it really varies. And in fact, one of the things that can be problematic with these is sometimes the heirs are minors. So when a person passes away, maybe they have a will, maybe they don't, but, and in fact, I will get to that when we talk about one of our case studies. So, as Lorraine mentioned, we do have a foreclosure mediation program in Connecticut that is available as of right if you are an owner occupant and the borrower. However, if you are an heir to the property and you live on the property, and this is your home, you might not have access to it because you aren't the borrower and you aren't on title. So sometimes these heirs are named in a foreclosure case and can petition for mediation because it is, the court does have discretion to refer people to mediation. However, they don't have the right to participate under the foreclosure mediation statute. And sometimes the person who is named as a defendant in the foreclosure case might not be the administrator or executor of the estate of the original borrower. So often you have two parallel timelines of one is a probate case moving forward in probate court, which is often very slow. And then you have a foreclosure case, which is trudging along in superior court as well. So trying to line these things up and make sure that the title issues are resolved, while also trying to navigate the complicated issues related to a foreclosure where there may be multiple heirs or heirs who have not been given access to the information they need with regard to the mortgage, can really create a number of complicating factors, and can have issues such as minor children who are the intended heirs, or multiple liens and creditors that also are coming to collect on debts, or have interest in the property. And let me give you an example. So one way that title can be tangled is with couples who were unmarried and have shared children. In this particular case, only one of the partners was on title to the property and the borrower on the loan, even though the family lived in the property together. There was also another child who was an heir to the homeowner, but lived not in the property with a former partner. So when the borrower passed away, all of the children were ultimately his heirs. But the surviving partner needed to work with the mortgage company in order to try and stop the home from being foreclosed on, and needed to get a release from the child that was not her shared child with the borrower. So fortunately, there was a relationship there between both the ex-spouse as well as the current partner that they were able to get a release of that particular child's interest in order to maintain sort of the family home. And ultimately, she was able to refinance. But the issue in that case was really ensuring that everyone had enough time to get all of this done. And if not for intervention, with that particular person and being able to sort of explain what was going on, identify what the issues and the speed bumps were in probate court, identify what the issues and the speed bumps were in foreclosure, she might not have had the time in order to get all of that done. So often the interventions in these tangled title cases are not predictable, and they're unique and sort of bespoke to each situation. So we have had to really get creative in our advocacy to try and address them and ensure that people can stay in the homes that are often, the only home they've ever known, or, a family home that's been, until the sudden death of a particular person, not in question and not really an issue of affordability for homeowners.
This case study in particular, Tess worked closely with another attorney, a private attorney, who is representing them on the probate side of things. And often with these cases, we have foreclosure attorneys on one end and then probate attorneys on the other end. And there is a real need for collaboration because each attorney only knows their lane and their half of the story. So there was considerable like collaboration that had to happen with timing, with the filing of certain things in either court in order to make this happen. And I will note in the chat, Raman mentioned that successors and interests are usually pushed to refinance the loan rather than assume or pursue loss mitigation, which is true. And for many of these errors, getting a refinance is much harder because either they don't, they don't have the credit for it is usually the case. It's not necessarily an income thing because we often walk people through what a modification or a new refinance would look like in terms of the monthly payment before when we're advising them. But it's often easier to assume a mortgage, especially for those people who had mortgages in the 3 to 4% rate, to be able to qualify for loss mitigation and reinstate the mortgage and assume it at a lower rate is the best possible resolution for that. But many times servicers will just say, well, let us know if you can refinance and pay this off, which for a lot of heirs means they're coming into the market at an interest rate of like 6 to 7%, which oftentimes may make the monthly payment unaffordable ultimately. Okay, so let's talk about zombie mortgages. So during particularly 2005 and 2006, almost every single mortgage that I would like qualify as a zombie was originated during that time, very particular neighborhoods and cities within Connecticut. And these second mortgages were part of 80-20 transactions, mortgage transactions that came as a result of reverse redlining that was happening in the Black and Latino communities when property values increased suddenly during that time period. And some folks had been in their homes already and refinance into these products. Some people were brand new homeowners. And how it looked was many times they were not underwritten very well, if at all. So we have spoken to a lot of people now that are dealing with these second mortgages that have popped back up that they don't even remember providing income information back then, or they took out a mortgage for $300,000 and only made $20,000 a year at that point. So we can tell very quickly that they probably, shouldn't have been qualified and that they were being targeted specifically for these transactions. So the transaction at closing looked like you signing a mortgage for 80% of the purchase price of the property, and then one for 20%, which was technically the down payment loan. And what happened is people defaulted on these loans when the market tanked. Some people held on for later, but about 2010, 2009, 2010, a lot of the homeowners that received these 80-20 mortgages were modified under the Home Affordable Modification Program, HAMP, under Obama, or the Obama plan as it used to be called, and ended up with loan modifications on their first mortgage that brought them down to 2% for 5 years, and then slowly going up year 6, year 7, and usually capping out at about 4% or 4.5%, which was great and allowed these folks to be able to afford their mortgage and keep their homes during that time period. It also made it so that they paid down a lot of principal during the intervening 14, 15 years since they received that. At the time that homeowners were receiving this loan modification, there was also a program that worked in conjunction with HAMP that was called 2MP. And if you received a HAMP modification, your second mortgage servicer, which for many times was the same servicer, should have offered you the opportunity to apply for this modification program on your second mortgage. And had you been approved at that point, you would have gotten a 1% interest rate for the life of the loan on what ended up being pretty trash mortgage products from that time period that were devalued. People at the time also, their property values completely tanked. Many of you remember there was no equity. So many homeowners were told by either counselors or other people that advised them with good reason to not worry about their second mortgage, to just worry on staying current on their first mortgage after they received their modification. And for that reason, many homeowners that we're speaking to now thought that that second mortgage was forgiven. A lot of these second mortgages were forgiven during that time period, like between 2010 and 2013, 2014. Many of them were forgiven. Many of them were charged off. So they remember receiving a letter that saying that the second mortgage had been charged off, which for the normal homeowner in your head, you assume, okay, I don't have to deal with this debt anymore. And you forget that you actually signed a mortgage, which is just attached to the value of your property and to the title on your property. Many homeowners also thought that the second was rolled into the first mortgage through the modification years ago. And again, it was a reasonable thing to think, because for folks that were getting modifications, they were recapitalizing or adding to the principal $30,000, $40,000, $50,000. So all of a sudden they see the balance on their first mortgage go up. And at the same time, they stop receiving statements from the servicers on these second mortgages. So it was reasonable for them to believe at that time that the second had either been forgiven, rolled in, or just like they didn't have to worry about it. What we're seeing now is the second mortgages that were not serviced during that very long time period have been sold off to other investors, and these investors are turning around and foreclosing on these homeowners who are confused. Many of them tell us they thought it was a scam. Many of them are confused to know that there's still a second mortgage on their property, and they will ignore it up until they get served by a marshal with a foreclosure here in Connecticut. Okay, Tess, you're handling the chat. Good. So this has had a national impact. This happened, you know, many inner city neighborhoods and areas were targeted across the nation, and now we're seeing the results of that. The CFPB, the Consumer Financial Protection Bureau, has been keeping its eye on this, releasing reports kind of warning consumers about the existence of this. You can move on. And in Massachusetts, very recently, probably just a month ago, the Attorney General of Massachusetts brought an action against Franklin Credit Management and ended up in a consent agreement and a settlement that required Franklin to stop collecting and attempting to collect these debts on Massachusetts and their entire Massachusetts loan portfolio. And Franklin Credit is one of the big servicers, and they own some of the loans, but they service a larger majority of these zombie mortgage loans. And some homeowners in Connecticut have had Franklin as a servicer from like month one. Some, you know, they've picked up on it since, but Massachusetts decided that it just was not going to allow these kind of junk debt buyers to come and force foreclosures in the state. So as a part of this, they have to stop collecting or attempting to collect in the state, and they also have to release the mortgages. And I confirm this with the AG's office because that's the more important thing. We want to make sure that people have the ability to sell their homes, and to also borrow against their loans if they need to, again, without having to deal with these mortgages. The bottom line is Massachusetts in this settlement alleged that it was so unfair to have even written these mortgages to start with, but then to have abandoned them for such a long period of time, laid and wait until the person paid down their first mortgage, and also the market went up to then force a foreclosure. And many of the people that we're talking to have significant equity now because they've been paying down a first mortgage at such a low rate over the last 10 or 15 years, and also because of the market increase over the last 3 or 4 years. And they're also requiring Franklin to make a $300K payment to the Commonwealth of Massachusetts for their wrongdoing. So the reason this is you know, near and dear to our heart is because one of our missions is to help people of color maintain their equity, maintain the wealth that they've been able to build during that time. And we also know that these investors purchase these loans on pennies on the dollar of what was originally borrowed. So many of them will make the argument in litigation, we're litigating these cases in Connecticut as well, that you know, the homeowner is receiving a windfall, but they purchase the loans for such a low amount that, you know, the reasonable thing to do would be to offer the homeowner a payoff of close, you know, throw a little profit in there for yourself, like a payoff that is close to what they purchased the loan for, but they are actually requiring people. For example, one homeowner I have in particular that I'm representing, she borrowed $39,000 in 2005, and that is now over $100,000 that she owes because they have also been charging interest on the principal during that time, despite not servicing the loan, not sending periodic statements, monthly statements. They will offer people modifications that require a $50,000 down payment and large monthly payments going forward. So it makes me exceptionally happy to see what Massachusetts did here. And we're spreading the gospel because I think it's something that other AG's office should take into consideration, especially ours. But while that happens, we are also fighting the good fight in Superior Court on these cases as well. So how we fight the zombies, litigation. Tess and I have several zombie mortgage cases, and in general, what we're alleging as a defense to the foreclosure is a theory called abandonment, which means that the servicer, the lender, the investor abandoned the loan long enough and showed an intent to abandon it for long enough that they should not be allowed to now enforce it. It's just it's a common law defense in foreclosure and in other parts of the law as well, where from a sense of fairness, it's not okay for a debtor to just lay in wait till like the person has more equity in the property without having done anything that they needed to do in the interim, and then be able to cash out on their investment when they've given the property owner no reasonable ability to reinstate, no reasonable ability to cure the default, and even no notice of the default or of the debt as it grew. We also are active in advocacy both in the state and nationally to kind of crowdsource what's happening in other states, what's working legally, what's working legislatively. And one thing that other states have that we don't is a statute of limitations on foreclosure, the amount of time that a lender has from default to enforcement of the loan. And many of these cases, and what many of these folks we're talking to, they defaulted 15 years ago. So some states will have a 6-year statute of limitations, like you must start a foreclosure within 6 years of a default. So that's something that we're taking into consideration and pursuing legislatively.
So I will give you another example. One way we're fighting the zombies. We had a family come to us. They were a limited English proficiency couple who were homeowners. They bought their first home in 2006. It was an 80-20 loan, just like Lorraine described. They financed the whole purchase price. And they had the big mortgage and the small mortgage. And not only were the terms of the loan itself predatory in that the monthly payment was vastly unaffordable in really by underwriting standards. But the closing documents were also incomplete, confusing, and ultimately, inevitably, they fell behind. So when they modified their first loan, just like we see in a lot of these cases, they assumed that their second mortgage was rolled into their first mortgage. And they have been paying their mortgage payments every month religiously. But ultimately, back in 2022, they started getting statements and collection letters from a company they didn't recognize for funds, for amounts that seemed so unreasonable that they assumed it was a scam until they got served by
what they borrowed originally and then how much they were told they owed.
I want to say it was 45,000, and I think the total is now up to 120,000. So really astronomical growth in the debt. And because these homeowners have been paying their first mortgage the whole time, and their home value has gone up, they do have equity in the property that is now completely at risk. So all of that wealth that they thought they were accruing over time is now at risk. So they were served with a foreclosure summons, and ultimately, this loan is one that we are convinced is not only has been abandoned because of the long period of no contact, but was ultimately predatory from its inception. And we see this among these zombie mortgages is that, like Lorraine said, they often target homeowners who may have English as a second language, first-time home buyers, with underwriting standards that were basically non-existent. So that's one case that we are currently working on,
and the predatory loan lending thing that Tess mentioned is also a defense in foreclosure. And sometimes we will rest on that one, we'll focus on that one, because with abandonment, I currently have a case that will be heard in the next couple of weeks in the appellate court about what really is abandonment in Connecticut. Because the cases that deal with abandonment and foreclosure are from like 1930. They do not take into consideration just the mortgage pooling that is happening, the selling of it for pennies on the dollar. There's a lot of things that are not taken into consideration that we're asking the appellate court to now consider, because many times some of these servicers will send just a random piece of correspondence every year just to kind of like as a place marker so that they would survive an abandonment defense potentially in Connecticut by saying, well, we sent this one letter once a year, every year, they should have known something was up. So in cases where that has happened, we are looking to see if they fit the kind of elements of a predatory loan defense as an alternative to the abandonment defense, so that their case can be litigated and survive the foreclosure. So we've had to get very creative about what can we allege was unfair about this particular transaction and their servicing or lack thereof over the last 10-15 years that would at least buy this homeowner some leverage in order to negotiate a modification that could possibly be affordable, if not, win the foreclosure and keep them from foreclosing.
Yeah. And I would say all of the homeowners that come to us are folks who are incredibly willing to pay their debts. They just want things to be settled and want to feel like they've had a fair opportunity to address these issues. But when they're presented with sums that are so astronomically inflated, it becomes impossible. And I think it's relevant to discussing, the Great Recession, the housing crisis may have been 10, 15 years ago, but ultimately we're still living with those impacts today. And, I don't know, I think it was Faulkner who said the path isn't dead. It's not even past. So
Yeah.
we're seeing those impacts just echoing throughout the housing market today.
Yeah. And the note in the chat kind of is a precursor to my next slide, so I'll address it there. So the other issue people are having are escrow issues with increasing property charges. So to your point, Raman, we do see these zombie mortgages popping up. For some people that are elderly now, may not have been when they first took it out, but they do have more equity because they're either close to paying off their first mortgage or they've, like I said, paid down a lot of it. And to your point about the surge in taxes, I mean, I always tell the homeowners that I speak to that like Connecticut is really not a place, unfortunately, for people to retire well, because taxes for many people are another mortgage, even after they feel like they're safe because they've paid off their mortgage. As taxes increase, it becomes less and less affordable for people to stay, even if they have no mortgage on the property. So I'm putting a link in the chat for a resource that exists. They've been able to aggregate the tax abatement and tax credit programs across the nation. so that you are able to look up your particular city and see what's available for homeowners. And it varies from city and town. They do it at different times of year. There's only you have to get your application for the abatement of the credit in by a certain time. And the times seem to be arbitrary to me, but they could very well be aligned with whatever the tax list is. And the tax increases every single year impact seniors more and more because they cannot keep up with it. And we also see it in cases that involve reverse mortgages because many people have pulled money out of their property that was supposed to last them a certain amount of time to cover taxes and insurance. And then either the money runs out or they have to use it for something else. And all of a sudden they're having to pay to stay on top of taxes and insurance, if not face a default on their reverse mortgage and a foreclosure. I will throw in for any of you that are advocates for homeowners that are 80 or more, there is an at-risk extension program that allows them to keep their home and stay in their home, even without paying the taxes and insurance. The servicer basically picks up the bill. It's a little morbid because the reason it's 80 and above is because they've quantified that it's likely the person is not going to live very much longer. So this relief program exists through HUD, where people can apply yearly, annually, certify that they have certain conditions that affect their daily life, and they're able to stay in their homes and stay independent, despite not being necessarily able to afford their taxes and insurance. But it's not something that servicers are offering up. You have to call and know that the program exists, which is unfortunate. There's also a nationwide increase in insurance and homeowners insurance, or homeowners being dropped from insurance altogether. And what happens when a homeowner is unable to obtain their own insurance policy is that the servicer will place a forced place insurance policy on their property, which really only covers the structure. It doesn't cover any personal items or personal properties. So it leaves the homeowner vulnerable for any type of property loss happening. And it also tends to be more expensive than what they were paying for a full insurance policy. What we'll see is homeowners receiving escrow notifications, every October or whenever you receive yours, and showing the escrow charges increasing over time and being spread over 12 months. You can request that your escrow be spread over more than 12 months, but a lot of people don't know that. It can be spread up to 60 months, which is much more affordable for people. And we're also seeing insurance increasing and being dropped from just natural disasters. So that has been top of mind, as well as climate changes and more disasters are happening. We are seeing more and more.
And I'm aware that we are just about
Yeah.
at time, but I do just want to show that we are keeping an eye on some other issues impacting homeownership. And that really speak to housing equity. So lending discrimination, appraisal discrimination, some of the FEMA and disaster relief issues we've seen happen in light of extreme weather disasters. So these are all things that Connecticut Fair Housing is keeping a close eye on. And I know we can certainly, we are happy to take questions either after the session, if you want to send them to us via email, or reach out after the conference. We are always happy to hear from people, but I'm going to drop my email in the chat as I know that we want to give you time to get to the reception.
Thank you, everyone, for joining us. If there are no questions, and as Teresa said, you can follow up with her via email. Just a friendly reminder, please take a moment to fill out the survey, the perceived survey. And with that, just want to say thank you for joining us and have a great afternoon.